Greetings, sports fans. Courts fans. Welcome to the arena, everyone. I'm Laura Wyrick, and I'm here with Ruth Rivera. Today, we will be observing an intensely adversarial game that will test the players' strength, speed, intelligence, and grit.
That's right. Court watchers have been talking about this one all season.
This case is being heard in the Indiana Supreme Court, which is the arena for today's matchup. For those of you new to the game, cases in Indiana start in the trial courts and, with a few exceptions, if one of the parties—
That's what we call the competing players, who are always represented by lawyers.
If one of those parties does not like the decision at trial, the party will appeal the ruling, and the case will move on to the Court of Appeals. Then, if one of the parties still is not satisfied with the outcome, that party may file a petition to transfer the case to the Indiana Supreme Court. The Supreme Court will decide whether it will hear the case. If so, the court will grant transfer, and the case will go before the Supreme Court.
Now that we're all on the same page about the process, let's introduce some of the most important people in the game today. Our reps, our umps, our officials. There are 5 justices presiding over this case.
All rise. Hear ye, hear ye, hear ye. The Supreme Court of Indiana is now in session.
These judges are the ones to impress. Their job is to listen to each argument, ask tough questions, and ultimately make a decision about who will go home a winner today. Now they will introduce the case and address the attorneys for each party.
Good morning. We are here to hear the argument in the case of Steve Jobs versus the state of Indiana. The court would like to recognize counsel for the appellant, Yvette LaPlante and Danny Campbell, and counsel for the appellee, James Dillon and Raeanna Spahn. Ms. LaPlante, you reserve 5 minutes for rebuttal. Is that correct?
That is correct.
Are the parties ready to proceed?
I guess.
Sure.
Yes, Your Honor.
As you heard the Chief Justice say, the individuals who will be presenting today are the attorneys for the appellant and the appellee. The attorneys for the appellant will present first. Then the attorneys for the appellee will present their case. And finally, the attorneys for the appellant will return for a rebuttal argument.
Before we move to the main event, let's talk a little bit about the facts of the case. The appellant, Steve Jobs, whose name is totally a coincidence, got into a car wreck, and witnesses say that he might have been texting or driving.
Right. And since that's against the law in Indiana, the police wanted to search his cell phone and see when his last message was sent and received.
But the U.S. Supreme Court has held that searching a cell phone requires a search warrant unless there are exigent circumstances. That justifies the police acting without a warrant. Specifically, an emergency situation where evidence may be removed or destroyed.
Police here said that they heard Mr. Jobs on the phone tell his friend, "My username and password are on a sticky note in my desk drawer. Just use Find My iPhone." In other words, it sounded like he was going to erase his phone.
So they made him hold his thumb to the sensor, and the first thing they saw on the screen was that he texted LOL to Bill Gates, whose name is totally also a coincidence here, right at the moment of the crash.
So if this whole Find My iPhone thing was exigent circumstances, it was okay not to have a warrant, and that texting evidence can come in. But if this didn't count as exigent circumstances, then the search violated Mr. Jobs' Fourth Amendment right against unreasonable searches and seizures, and it should have been excluded from the evidence.
That's why before trial, Steve Jobs' attorneys moved to suppress the cell phone data evidence, and why they objected to that evidence when the state introduced it.
Alas, the trial court denied his motion on the grounds that exigent circumstances existed justifying the warrantless search. With that evidence in, a jury in Tippecanoe County ended up convicting Jobs of reckless homicide and texting while driving.
So Jobs appealed, arguing the cell phone data never should have been presented. But the Court of Appeals affirmed, agreeing with the state. As a last resort, his attorney filed a petition to transfer, which the Supreme Court granted. And that's what brings us here today. Now, Steve Jobs' attorney is up, and she will present her argument.
Okay. Thanks, Judge. So, the search wasn't constitutional, okay? Because, the cops didn't have a warrant for my client's iPhone.
Oh man, that's gotta be one of the worst fumbles I've ever seen in an opening statement. You always open with, "Thank you, Your Honor," or "Chief Justice," and then, "May it please the court." When the first thing you say is a decorum foul, you know it's going to be a rough day.
No kidding, and not making eye contact with the justices, your opening line might be the only opportunity where you don't get interrupted. So you should definitely memorize, and you can look at the justices in the eyes to make that connection with them right off the bat. You also have to know it well enough not to or okay your way through it.
She didn't even ask if the court would like a brief summary of the case. Some courts want it, some courts don't, but it's always good to offer. You don't want to risk the court being unfamiliar with your case, so they have trouble following your argument.
And the disrespect calling the police cops. I'm afraid counsel is not off to a strong start.
Without a search warrant.
But counsel, isn't it undisputed that
the search was just
doesn't
way
everyone
illegal.
agree that there was no warrant? Isn't the real issue whether there are exigent circumstances?
Failure to listen to the question the justice was asking before answering the question. That's a 10-yard penalty. Repeat. First warning.
Now that's really going to hurt their case. They're not going to be persuasive by interrupting a judge. That's just rude.
Right, you're trying to convince the judges of your position. So if one of them asks a question, you really ought to stop and listen. If you won't even listen to their question, how can you answer it well? It's your answers on the spot that are going to win the judges over, not a speech that you've prepared.
Now, counsel, as my colleague was attempting to inquire, aren't you missing the point talking about a search warrant when the question here, in this case, is exigent circumstances?
Well, the Supreme Court says you have to have a search warrant.
Ooh, unresponsive answer. That's a real missed opportunity.
But the case also leaves room for exigent circumstances. Why isn't a threat to remotely wipe the phone data an exigent circumstance? And if your client was to go through with that, there wouldn't be any evidence to find with the warrant.
But it was my client's passenger who was texting, and my client was talking to a friend about something totally unrelated.
Ouch. Not only has counsel never told the court the standard of review, now she's arguing the wrong side of it. On this issue, the appellant side has to live with the version of the facts the trial court believed. And in the trial court here, they didn't believe this testimony. A real rookie mistake.
The appellant's time is way more than halfway up. The counsel really needs to be looking for an opportunity to yield the floor to her teammate, or else co-counsel's really going to get the short end of the stick here.
Exactly. Managing the handoff is the job of the first attorney, not the court. This really could put co-counsel in a jam.
Counsel, wasn't there expert testimony about how Find My iPhone can be an easy way to remotely wipe all the data off an iPhone? Even if there was an innocent misunderstanding about who was texting, doesn't that testimony really bolster the trial court's conclusion that there were exigent circumstances?
I think it's Ms. Campbell's turn. I see my time is almost up.
Unbelievable. After waiting all of this time to make a handoff, did they really just use it as an excuse to duck a tough question?
Even when your time is up, you always say, I see my time expired. May I answer briefly? The judge always wants to hear an answer to their question. That's why he or she asks.
Leaving it hanging like that is a really bad form. This is not the kind of argument that's going to make the playoffs. And their side barely has 1 minute left on the clock.
May it please the court. My name is Danny Campbell, and I'm co-counsel for the appellant, Mr. Steve Jobs. It's a privilege to argue in front of all of you today. Let me just say what an honor it is to be in all of your esteemed presence.
At least she got may I please the court, but their side is almost out of time, and they're wasting it on sucking up to the court.
In a moot court contest, though not usually in a real argument, sometimes it is helpful to give your name so judges don't mix up the scorecards. Anything beyond may it please the court and your name is just using up time that you could be using, making the persuasive argument that the court is looking for.
I'd like to begin by answering the question you asked my co-counsel.
This could be good.
But I see my time's up, so I guess I can't.
Oh no, she almost had it, but then blew it by not asking for more time to answer.
And not having a one-line summary of what you want the court to do, something like, we asked you to reverse the trial court. You're just not capitalizing on your last chance to score a point with the court.
I hate to say it, but if I were the coach, I'd be worried whether my contract was going to get renewed after that performance.
Wait, a police counsel is approaching the lectern, and look at that demeanor. Even before saying a word, the judges are paying attention. Folks, this is really shaping up to be a blowout.
May it please the court. My name is James Dillon. Although counsel for the appellant has tried to muddy the waters on appeal and raise a number of issues, the single question before the court is simple. The court should affirm the trial court, which correctly denied the defendant's motion to suppress the cell phone evidence.
This is excellent. A short, concise statement of the issue right out of the gate. Let's see what happens next.
The standard of review when reviewing a trial court's denial of a motion to suppress is well settled. This court does not reweigh the evidence and will only consider the evidence most favorable to the trial court's ruling, along with any uncontroverted evidence to the contrary. Your honors will determine whether substantial evidence supports the ruling below.
Look at how he skillfully recited the court standard of review up front. And rightly so, the standard is favorable to the appellee here. So it's a good thing to get it out in the open. Hopefully we get a roadmap soon to tell us what arguments counsel will be making.
The motion to suppress was properly denied for two reasons. First, there was substantial evidence before the trial court that exigent circumstances existed, relieving Officer Gold and Officer Mitchell of the need to obtain a search warrant before searching the defendant's cell phone. Second, there is no uncontroverted evidence to the contrary, which would suggest that exigent circumstances did not exist.
There's that roadmap you were looking for. He clearly lays out what the general arguments are. Let's see if he can stay organized with that roadmap and not get thrown off much by the judge's questions.
Counsel, I'm interested in hearing about your second point first. Now, wasn't there testimony at the hearing in the motion to suppress from the passenger in the car, Mr. Hackney, that Mr. Hackney was the one texting the defendant's phone at the time of the accident? And isn't that uncontroverted evidence that weighs against the admission of evidence at trial?
Respectfully, Your Honor, no. This is not the type of uncontroverted evidence that would outweigh the substantial evidence in the other direction that was before the trial court. Evidence of who was actually operating the cell phone at the time of or immediately prior to the accident might be relevant at trial, but it has no bearing on whether exigent circumstances existed at the time of the search to allow the officers to search without a warrant. Quite frankly, the defendant presented no uncontroverted evidence at the hearing to show that exigent circumstances did not exist. So, with respect to the second prong of the court's standard of review, there is nothing for the court to consider, which means the only real issue remaining is whether there was substantial evidence before the court supporting the court's denial of that motion.
Wow, let's break this down.
Yeah, first, counsel was not thrown at all by the judge's question. It took him off of his roadmap, but he remained flexible and adapted his argument easily. That's really important. Second, in response to the judge's question, counsel gave a short, direct, yes or no answer, and then went on to explain that answer. Great job. Third, counsel was respectful and deferential to the judge, even though he was disagreeing with him. And finally, counsel transitioned nicely from the answer to the judge's question back into his argument outline. Nicely done.
Nicely done.
I see that my time is up. If the court has no further questions on this issue, I will now hand my remaining time to my co-counsel.
May it please the court. As my colleague has stated, the record here shows there was substantial evidence before the trial court to support the denial of the motion to suppress. Officer Mitchell testified at the hearing that he overheard the defendant say, and I quote, "They took my phone. My Apple ID and password are on my desk. Just use Find My iPhone," end quote. Officer Gold testified that Officer Mitchell told him at the scene what Officer Mitchell had overheard. Further...
Wait just a minute, counsel. Isn't Officer Gold testifying that Officer Mitchell told him what he overheard classic hearsay? Should that testimony have even been allowed at trial?
Your Honor, it very well may be hearsay, but counsel for the defendant did not object to Officer Gold's testimony at the hearing, so the issue is waived on appeal. In addition to the two officers' testimony, a technology expert then testified that the Find My iPhone function on an iPhone is an easy and common way to remotely wipe all the data on the iPhone. The only logical inference from all of this testimony is that the defendant was instructing his friend, Mr. Hackney, to go to his desk, retrieve his Apple ID and password, and wipe his cell phone using the Find My iPhone function. This clearly shows that the cell phone evidence was at risk of disappearing. Under the court's reasoning in State versus Alexander Graham Bell, a reasonable belief that cell phone data will disappear or expire constitute exigent circumstances to search the cell phone without first obtaining a search warrant.
Counsel's answer to Judge Fischesser's question really hit the nail on the head. Sometimes a simple answer like this one, bringing up the defendant's waiver of an argument, is the best answer. Notice how counsel paused after her answer to make sure the judges were satisfied before she moved on. That's a veteran move, one that some of us in the game call the yes, but answer. It's pretty effective.
It looks like Justice McCready may be ready to ask a question. Let's see.
Counsel, you talk about the case of State versus Bell and a reasonable belief that cell phone data will disappear. Did Officer Mitchell testify at the hearing that he knew what Find My iPhone was and that it could mean that the cell phone data would disappear?
Oh, a tough question about the record. Let's see if counsel knows the record well enough to answer the question. You really do need to know that forwards and backwards.
No, Your Honor. Officer Mitchell testified that he is not very tech savvy and unfamiliar with what Find My iPhone meant. However, Officer Gold testified at page 22 of the transcript that he was aware that iPhone users are able to wipe their devices by using the Find My iPhone function, and that he shared this information with Officer Mitchell at the scene. This is sufficient to show the reasonable belief necessary under the Bell standard.
It looks like counsel has a good handle on the record. She was even able to cite the transcript page. Impressive.
Counsel is running low on time. She needs to wrap up quickly.
I see that my time is expiring. In conclusion, the state of Indiana respectfully requests that this court find the trial court was correct in denying the defendant appellant's motion to suppress. Thank you.
Counsel succinctly wrapped up her argument in a few seconds by having that request for relief prepared in advance. A nice end to an all-around excellent argument. Well done. Let's see if appellant can rally and rebuttal and end this argument on a high note.
Indeed. Now the rebuttal is a strategic sport in itself. To rock the rebuttal, you really have to be on your game during the entire appellee's argument, taking note of the key parts and thinking carefully what your counter-attack would be.
All true, but you have to remember that oral argument, even the rebuttal, should be a civil conversation between the attorney and the bench. So the appellant needs to strike a balance of being firm and persuasive, yet respectful to the other side.
Your Honors, I'd like this time to address and clarify 2 points. First, the lack of probable cause, and second, the importance of privacy interest.
Great start. Calm, collected, and confident. She waited until the bench was ready to proceed and provided a mini roadmap, and is helping all of us keep our eyes on the ball, focusing us on the specific issues the appellant wants to discuss.
First, opposing counsel stated the officers had no reason to believe data may be destroyed, but the test for exigent circumstances, as articulated in this court's recent opinion, State versus Vicky Verizon, has 2 prongs. It also requires that the officers have probable cause to believe that a crime has been committed.
Wow, the appellants sure stepped up to the plate here. They were obviously paying attention to the other side's argument and are now making a direct response.
And a response based on the case law to boot. By citing authority like that, she really increases her credibility.
But counsel, we know there was a crime. Tragically, someone died as a result of your client's behavior.
Although you are correct, Your Honor, in that Mr. Pat Pedestrian lost his life, the evidence shows that officers did not actually have probable cause to believe the death was a homicide. Indeed, Jobs and Hackney, the only witnesses to the accident, testified on pages 45 and 62 of the record that what occurred was just that, an accident. Jobs told the officers at the scene that Pedestrian came out of nowhere. He was simply unable to stop at the time. Moreover, the 2 raised concerns about the brakes in the car, which may not have been functioning properly. Without probable cause, the search of the phone violated Jobs' Fourth Amendment rights.
Another impressive answer with a cite to the record. We've got a full court press here.
That brings me to my second point. Your Honors, that is the importance of the privacy interest at stake today. Cell phones are significantly different from wallets, address books, and other items found on a person being searched in police custody. They're digital records of nearly all aspects of a person's life. Everything from their whereabouts minute by minute, the personal finance information, and even their most personal communications. And given the admitted storage capacity, this information is vast. Weighing our constitutional right to privacy and the lack of cause to perform this search, the cell phone data evidence that you should have been excluded. We therefore ask this court to reverse the trial court's decision. Thank you.
Wow, the appellant really made up some ground in rebuttal. While the judges finish scoring, let's take a look at some last-minute tips and reminders that are sure to make you the winner on every judge's scorecard.
Number 1, always show deference to the court. Begin with the statement, "May it please the court," or "Thank you, Your Honor." This establishes that you respect the court and are ready to start your argument. Also, be sure to leave your cell phones, PDAs, and other electronic devices at home, as they might distract the judges from the argument.
Number 2, begin your argument with a brief statement of the issues, followed by the standard of review. The key word here is brief. This statement should only last for, at most, 1 minute, and be short, concise, and to the point.
Number 3, following the statement of issues, provide the court with a roadmap of what arguments you will be making. This helps the judges know where you will be going with the argument. The roadmap can also help you refocus if you later become sidetracked by judges' questions.
Number 4, listen carefully to the judges' questions and answer respectfully with a short yes or no answer. Then explain your answer. Never cut off a judge when he or she is asking a question.
Number 5, make sure you know all of the applicable facts and case law as it applies to your argument. You never know what questions will be asked during oral argument, so it helps to be over-prepared.
Number 6, rebuttal should be brief and only respond to arguments made by your opponent. Do not use time during rebuttal to bring up or restate earlier arguments.
Finally, number 7, be aware of your time and conclude the argument with a request. It is important to pace yourself throughout the entire argument. So, keep an eye on the clock and make sure you have enough time to present your strongest arguments and a conclusion.
Oh, it looks like the judges have made their decision. Let's see who's today's winner.
While both sides made some truly excellent points, the appellant fumbled throughout their argument and made too many rookie mistakes to overcome their opponent. In contrast, the appellee handled their argument with poise, deference, and respect. As such, we are declaring the appellees as today's winner. Thank you to both parties for your time and for demonstrating the importance of an oral argument. May the odds of winning be forever in your favor.